Welcome to This Explainer. Today, we are going to methodically break down the complex legal architecture that governs the creation and sale of commercial vessels. A shipbuilding contract governs the incredibly high-stakes creation and sale of a vessel. And its legal framework dictates who bears the financial risk if the shipyard fails before the ship even exists. Here's our syllabus for mastering these legal doctrines step by step. We'll cover everything from the threshold of legal classification to standard forms, key clauses, financing, the Indian context, and we'll wrap it all up with a structured recap. Okay, let's start with Section 1, legal classification and ownership. We really have to begin with the threshold question that dictates the entire body of law governing the deal. So, the very first question we have to answer is this: is a shipbuilding contract a contract for the sale of goods, or is it a contract for work and materials? Now, you might be thinking, who cares? But this isn't just academic pedantry. This classification determines critical implied terms like fitness for purpose when things go wrong. Think of it like this. If you buy a ready-made suit off the rack, you're buying a good. But if you hire a tailor for their time, their skill, and their fabric to craft something completely unique for you, you're paying for work and materials. The legal expectations for the final product differ entirely between those two scenarios. Legally speaking, classifying the transaction as either a sale of goods or a contract for work and materials dictates the governing statutory framework and the implied protections afforded to the buyer. Let's look at exactly how English law settled this in the foundational 1958 case, McDougall v. Aero Marine of Emsworth Ltd. The facts here are pretty straightforward. There was a contract to build and sell a yacht. The issue before the court was whether this specific arrangement was a sale of goods or merely a contract for work and materials. Well, the holding of the court was decisive. They said it is a contract for the sale of future goods under the Sale of Goods Act. The rationale behind this decision was that ownership passes to the buyer only once the goods, meaning the vessel in this case, actually come into existence and are appropriated to the contract. And this remains the doctrinal starting point across the entire common law world. Let's make sure we define our terms clearly. A contract for the sale of future goods is a contract where the transfer of property occurs only at a future time when the goods actually come into existence. To put that in plain language, imagine hiring a carpenter to build a custom table. It's not legally your table until it's fully built and explicitly set aside for you. So, returning to the precise rule, because of this doctrine, ownership of a ship transfers only when it exists and is appropriated to the contract. Now that we know the governing law, let's examine the three major standard forms the international industry relies on in Section 2. These are the blueprints of the deal. There are three key standard forms we need to understand. First up is the SAJ form, originating from the Shipbuilders Association of Japan. This is the dominant standard globally, and it's generally regarded as heavily builder-friendly. Second, we have NEW BuildCon, which was created in 2007 by an organization called BIMCO. This one was developed specifically to be a more balanced alternative to the yard-favoring forms. And third, the AWS form, from the Association of West European Shipbuilders, which, as you might guess, is primarily used in European yards. The key takeaway here is that a buyer's legal risk changes significantly depending on which geographic standard form is chosen as the baseline for the contract. Moving right along to Section 3, let's dive into the contract itself. We're going to patiently dissect the 10 clauses that actually matter, starting with how the builder gets paid. Clause 2 outlines price and staged payments. Now, in the SAJ structure, payments are tied to milestones. There are typically 5 big ones: contract signing, steel cutting, keel laying, launching, and finally delivery. Think of this like paying a general contractor to build a house for you. You don't just hand over the full price up front, right? You pay as the physical work progresses and specific phases are completed. The strict legal mechanism at play here dictates that the buyer makes installment payments tied strictly to verifiable construction milestones before they ever take final ownership. Which leads us directly to Clause 7, the refund guarantee. Honestly, this is the clause that makes the entire structure work. It's a bank-issued guarantee ensuring that those pre-delivery installments are refunded to the buyer if the builder defaults or becomes insolvent mid-construction. Think of buying an unbuilt house in a new subdivision. You absolutely need a massive safety net just in case the developer goes bankrupt before your house is finished. Without this strict legal guarantee, the buyer is really just an unsecured creditor standing in line at a failed shipyard. In strict legal terms, the refund guarantee secures the buyer's pre-delivery installment payments against shipyard insolvency or default. Now, clauses 1 through 5 meticulously allocate the operational risks of delays and defects. Under Clause 1, the specifications and plans actually override the general contract terms if the two ever happen to conflict. Clause 3 covers the delivery date and liquidated damages. It usually caps late fees, but if delays cross a certain threshold, it triggers an outright cancellation right for the buyer. Clause 4 defines permissible delays, meaning force majeure events or buyer-caused delays actually extend the final delivery date penalty-free. And Clause 5 is the warranty, where the builder legally guarantees against defects, typically for a period of 12 months post-delivery. Rounding out our 10 clauses, we have the compliance and resolution mechanisms. Clause 6 ensures inspection and sea trials, giving both the buyer and the classification society the right to test the vessel. Clause 8 handles title and risk transfer, which, as we saw in the McDougall case, passes on delivery, unless you've specifically negotiated for progressive transfer. Clause 9 is absolutely vital: classification and regulatory compliance. You see, a ship must meet international safety and environmental standards, like SOLAS for safety at sea and MARPOL for marine pollution, and it has to pass specific classification society rules, such as Lloyd's, DNV, ABS, or India's IRS, before it can legally take to the sea. Finally, Clause 10 dictates dispute resolution, which historically defaults to London arbitration under English law. All right, Section 4, the financing security layer. The crucial point we need to understand here is that while the refund guarantee beautifully protects the buyer, the builder also needs absolute financial security. So the builder relies on what is called a builder's lien. This is a legal security interest allowing the builder to hold the vessel under construction against unpaid amounts, because legally, the vessel is the builder's property until delivery. It is exactly like a mechanic holding your car in their garage until you pay that massive repair bill. They retain physical possession as leverage. Getting back to the precise rule, this lien is legally enforceable exclusively because the builder retains ownership of the asset until the exact moment of final delivery and appropriation. Let's move to Section 5, the Indian shipbuilding context. We need to contextualize this entire framework for India, which notably lacks a dedicated, standalone shipbuilding statute. So, Indian contracts are domestically governed by the Indian Contract Act of 1872 and the Sale of Goods Act of 1930. Indian courts apply these acts identically to the McDougall precedent we discussed earlier, treating ships as future goods. When foreign entities are involved, those international standard forms are simply layered on top of domestic law. Now, the major domestic players, Cochin Shipyard, Garden Reach Shipbuilders, and Mazagon Dock, are primarily defense-focused right now. However, they are increasingly competing commercially, and the government actively uses financial assistance schemes to make these three major yards globally competitive against the massive shipping titans in places like Korea and China. Let's move to our final section, the structured recap. Let's really lock in what we've learned by tracing the exact sequence of concepts we've covered today. Let's run through a final mental checklist to make sure this correct terminology is fully cemented in your mind. First, the threshold classification. It is a contract for the sale of future goods governed by the Sale of Goods Act, not a contract for work and materials. Second, the foundational case, McDougall v. Aeromarine, which definitively held that ownership passes only upon the vessel's existence and appropriation. Third, the standard forms. The SAGE-I is builder-friendly, New Build Con is balanced, and AWS is European. Fourth, the crucial clause. The refund guarantee acts as the safety net protecting the buyer's stage payments. Fifth, the security layer. The builder's lien legally protects the yard's unpaid invoices by holding the asset. And finally, the Indian context. Shipbuilding is governed by the 1872 and 1930 Acts, and it's adapting to global commercial standards through government financial backing. Before we go, I want to leave you with a thought. As ships radically evolve to run on green fuels and eventually autonomous navigation, how will these rigid, traditional, standard forms adapt to the entirely new risks of tomorrow? Thank you for engaging in this explainer. Keep questioning the law and keep learning.